Dear Professor Alexandra, dear colleagues, ladies and gentlemen, thank you very much for the invitation, and thank you very much for the possibility to present some words about, I think, very important things as is technology, assisted reproductive technologies. A lawyer is not a prophet or a fortune teller. When he asks what about the future, it's difficult to expect him to answer the question of what will happen in the future, even when it comes to legal provisions. As lawyers, we are aware that legal regulations are created on the basis of past experiences and under the influence of current, sometimes shocking, sometimes important events. The provisions of the law created in this way are not be in force in the future, pro futuro, with all its consequences, both of the part those who apply the regulation of those who implement them. So, in my paper, first of all, I will point to the current lege lata status in the use of assisted reproductive technologies. It will be a short summary of my research, at the effects of which will be published in our monograph, edited by Professor Közép-európai. Secondly, and finally, the lege ferenda, I will outline the potential risk and direction for the development of an international legal standard in the field of art. So, the first point of my presentation, status de lege lata in the use of assisted reproductive technology. International law instruments of a universal nature concerning the protection of human rights, such as the Universal Declaration of Human Rights of 1948, the International Covenant of Civil and Political Rights of 1966, and the International Covenant of Economic, Social and Cultural Rights of 1966 do not contain provisions directly relating to assisted reproductive technologies. This is mainly due to the time of their adoption by the United Nations and the fact that at this time, this type of reproduction methods were unknown. The same is true of the Convention of the Rights of the Child of 1989. In addition to the universal documents, regional regulations are important for the development of international standards for the use of assisted reproductive technologies. Due to the perspective of the Central European countries, European regulations are of key importance of this respect, created both at the level of the Council of Europe and at the European Union. The 1950 European Convention of Human Rights and the Fundamental Freedoms, because of its similarity to the Universal Declaration of Human Rights of 1948 and the International Acts of Rights 1966, does not contain provisions directly relating to art. The European Union has some references in this law to the issue of assisted reproductive technologies. The Charter of Fundamental Rights of the European Union contains provisions protecting human dignity, the right to integrity, privacy, and health protection, and prohibiting of discrimination. On the other hand, the Treaty of Lisbon showed that the European Union cannot impose uniform regulation of ERAT, but it can influence the protection of human rights and the elimination of discrimination, which means, in accordance with the principle of subsidiarity, maintaining a certain autonomy of the member states in the field of ART, testing, processing, storage, and distribution of human tissue and cells, which also include gametes and embryos. In legal analysis based on these documents, assisted reproductive technology is usually indirectly referred to by provisions concerning the right to privacy, the right to establish a family, or the right to health protection. For example, the Convention of the Rights of the Child was adopted by United Nations in 1989. The articles on the best interest of the child, Article number 3 of the Convention, the right to identity, the knowledge of one's parents, Article 7 and 8 of the Convention, or the right to parenting, Article 9 of the Convention. Refer to the artificial assisted reproductive technology only indirectly. In the case of the living instrument, which is the European Convention for the Protection of Human Rights and Fundamental Freedoms, the European Court of Human Rights plays an important role in the application of its Article 8 on the right to privacy to assisted reproductive technology. Examples of such a broad interpretation of the right to privacy are the judgment, for example, Evans versus the United Kingdom, SH and others versus Austria, and Costa and Pavan versus Italy. The analysis allowed us to conclude that the European Human Rights Court had a great influence on shaping legal standards for assisted reproductive technology in Europe through its jurisprudence. At the end of the 20th century, we observe an increase in the activity of the international legislator, universal or regional, in issues concerning the application of ERT. A contrario of the professor's argumentation, the development of modern technologies, including those related to reproduction, contributed to the need to refer directly, not only by the way or by way of interpretation, to these issues not only at the national level, but also at the international level. The general principles of human genome protection that affect the ethical and legal aspects of assisted reproductive technologies are contained in the Universal Declaration of the Human Genome and Human Rights of 11 November 1997, adopted by UNESCO. The provisions of this declaration referring to human dignity should be considered extremely important. The human genome is the common heritage of humanity, Article number 1 of the declaration. And human dignity requires recognition and respect for the human genome, Article number 2 of the declaration. It should be noted that the issue of the use of assisted reproductive technologies is addressed by so-called expert documents, such as the Declaration of Sexual and Reproductive Rights, adopted by the World Association for Sexual Health in 1999, updated in 2014, and the Casablanca Declaration, announced on 3rd of March 2023. In the first document, the rights of women, LGBTQ+ people, and sexual minorities were reaffirmed. Unfortunately, it lacks guarantee concerning respect for human dignity and the rights of conceived child, also with the help of assisted reproductive technologies. The goals of the signatories of the Casablanca Declaration is to strive for the universal abolition of the practice of surrogacy. The key documents in the field of bioethics and human rights in medicine in Europe is the Oviedo Convention for the Protection of Human Rights and Dignity of the Human Being in the context of application of biology and medicine, adopted by the Committee of Ministers on 19 November 1996. Although it does not refer directly to assisted reproductive technologies, its provisions may nevertheless have an impact of the regulation. It follows from Article 18 of the Convention that research of human embryos may be carried out only within the limits of national law, which has an impact of the issues of cryopreservation of embryos in their use. The Convention also prohibits cloning in human reproduction. What future awaits assisted reproductive technology from a legal point of view? The use of assisted reproductive technologies in the future will be associated with, among other things, advances in the personalization of treatment, new methods of treating male infertility, new methods of freezing gametes and embryos, the use of artificial intelligence for embryo segregation, and the creation of artificial gametes and uteruses. The use of such often controversial technologies required a broad ethical and legal debate. The undoubted advantage of this type of activity include, above all, the possibility of having a child by couples who cannot have a child naturally, and the potential elimination of genetic diseases in embryos. However, progress in assisted reproductive technologies is associated with a number of threats that we are not even able to predict at present. The first group of health risks concern children conceived with the help of art, namely an increased risk of birth defects, epigenetic disorders, and an increased risk of premature and low birth weight, especially in the case of multiple pregnancies. The second group of risk is the health risk for mothers, in particular through ovarian hyperstimulation syndrome, increased risk of pregnancy complications, and hormone-dependent cancers. Long-term use of hormonal therapies can potentially increase the risk of ovarian and breast cancers. The third group of medical risk in assisted reproductive technology with the unknown and unpredictable consequences of embryo gene editing. Medical and non-medical doubts are raised by issues such as the fate of surplus embryos, gamete trafficking and surrogacy, the effect of cryopreservation, psychological pressure on couple or distribution of biological ties, and others. It is also difficult to predict the long-term consequences of the development of assisted reproductive technologies, which include, for example, social inequalities. In such a situation, lawyers cannot remain silent, especially since the existing legal regulation can hardly be considered sufficient and satisfactory. The process of shaping the international standard for the use of assisted reproductive technologies, which has been ongoing since at least 1948, the adoption of the Universal Declaration of Human Rights, has not ended. Moreover, the cultural, religious, social, and consequently legal pluralism of the contemporary world, including the European region, is unlikely to contribute in the coming years to the adoption of a single universal model for the application of assisted reproductive technologies. Nevertheless, it remains imperative to presently and unrelentingly advocate, contrary to the prevailing narrative, for the protection of the dignity and rights not only of parents, but also, and perhaps most importantly, of children, in the name of respecting their inherent dignity and best interests. Thank you very much for your attention.